Right. Hello. Polygamy. It's one of those words that immediately conjures up images, doesn't it? For some, it's a fringe religious practice. For others, it's the premise of a slightly uncomfortable reality TV show. But what is it really? Simply put, polygamy is the practice of having more than one spouse at the same time. While it might seem like a major global phenomenon based on how much it's discussed, it's actually quite rare. Only about 2% of the world's population lives in polygamous households, and the practice is concentrated in a relatively small number of countries, primarily in Africa and the Middle East. It's a complex topic, tangled up in religion, culture, and law. And that's what we're here to talk about today, the law. Because while the moral and social debates can go on forever, the legal status of polygamy is, in some places, surprisingly clear-cut. In other places, it's a complete mess of conflicting civil codes and customary laws, which is, of course, far more interesting. We're going to take a whirlwind tour of 5 countries where, in some form or another, polygamy is legally permitted. We'll look at the specific rules, the cultural context, and the often bizarre stipulations that govern the practice. It's a journey that will take us from the Arabian desert to the archipelagos of Southeast Asia. So buckle up. We're about to dive deep into the legal labyrinth of plural marriage. We'll explore who can have multiple spouses, how many they can have, and what hoops they have to jump through to make it official. This isn't about judging whether it's right or wrong. It's about understanding how it works in the places where it's still a part of the legal and social fabric. We're going to look at Saudi Arabia, South Africa, Indonesia, India, and Nigeria. It's a legal safari, if you will, but with significantly more paperwork and slightly less risk of being mauled by a lion. Though depending on the family dynamics, I can't promise it's entirely risk-free. Let's start with a country where the rules on polygamy are, or on the surface at least, relatively straightforward: the Kingdom of Saudi Arabia. If you were to guess a country where polygamy is legal, this one would probably be high on your list, and you wouldn't be wrong. It is indeed legal and fully recognized under the country's legal framework, which is deeply rooted in Islamic Sharia law. It's a system that has been in place for centuries and continues to shape every aspect of life, including marriage. The practice here is specifically polygyny, which means one man can marry multiple women. And there's a very specific number attached to that: 4. A man can have up to 4 wives simultaneously. This isn't some arbitrary number pulled out of a hat. It's derived directly from the Quran, which is the central religious text of Islam. The verse in question is often cited as the basis for the 4-wife limit, and it's the foundation upon which the entire legal structure of polygamous marriage in the kingdom is built. But, and this is a very important but, it's not a complete free-for-all. It's not like a game of marital Pokemon where the goal is to catch them all up to the limit of 4. There are significant conditions attached, at least in theory. The most critical requirement stipulated in Islamic jurisprudence is that the husband must treat all of his wives with perfect equality. This isn't just about buying them all the same brand of car, it's about providing equally for them financially, emotionally, and in terms of the time he spends with each. Now you might be thinking, perfect equality sounds difficult, and you'd be absolutely right. It's an incredibly high bar to clear. How does one precisely divide their affection and attention into 4 equal quantifiable units? It's a philosophical and practical nightmare. Critics of the practice, both within and outside the Muslim world, argue that achieving this level of perfect justice is humanly impossible, and therefore the condition essentially acts as a subtle prohibition. However, in practice, the legal system in Saudi Arabia doesn't typically get involved in measuring a husband's emotional equity. The enforcement of this equality clause is often left to the individuals involved and, frankly, to God. The state's primary concern is the legal contract of marriage. As long as the man has the financial means to support multiple households, a requirement that is taken quite seriously, the marriage is generally permitted without a deep dive into his emotional spreadsheet. So, for a man in Saudi Arabia to take a 2nd, 3rd, or 4th wife, he must demonstrate that he can afford it. This includes providing separate housing for each wife if they so desire, and ensuring that all of his families are maintained at a comparable standard of living. He can't have one wife living in a palace while the other is in a shed. It's a significant financial undertaking, which is one reason why the practice, while legal, is not as widespread as you might think. Furthermore, there are rules regarding the existing wife, or wives. In some interpretations and legal applications, the husband may need the consent of his current wife before taking another. However, this is not a universally enforced law across the kingdom. More often than not, the first wife's legal power to prevent a subsequent marriage is limited. She might have the right to request a divorce if her husband takes another wife against her wishes, but she can't necessarily veto the marriage itself. This creates a complex dynamic. The law provides a framework, but the reality is shaped by wealth, family pressure, and individual negotiations. The first wife's opinion might carry significant weight in one family and none at all in another. It's a system that, while legally defined, leaves a vast amount of room for personal interpretation and inevitably for potential conflict and heartbreak. In essence, polygamy in Saudi Arabia is a legally sanctioned institution with clear roots in religious text. The law sets a limit of 4 wives and imposes a condition of financial capability and equal treatment. But how that equality is measured and how the dynamics play out behind closed doors is a far more complicated story, one that the law books can only begin to describe. It's a perfect example of how a seemingly simple rule can have incredibly complex human consequences. All right, let's pack our bags and head south, way south to South Africa. Now, if you thought Saudi Arabia was straightforward, prepare to have your mind gently twisted into a legal pretzel. South Africa is fascinating because it's a country that essentially says no, but also yes to polygamy. It's a place where 2 parallel legal systems exist side by side, and they have completely different things to say about the matter of multiple spouses. It's the legal equivalent of its complicated relationship status. First, you have the civil law system, which is based on Roman Dutch law inherited from its colonial past. Under this system, which governs civil marriages, the kind of marriage most Westerners would recognize, polygamy is strictly illegal. The Marriage Act of 1961 explicitly defines marriage as a union between one man and one woman. If you try to enter into a second civil marriage while your first one is still valid, you're not just breaking the rules, you're committing a criminal offense. It's bigamy, and it can land you in serious trouble. So, case closed? Not even close. Because running parallel to this is the world of customary law. South Africa officially recognizes the traditional legal systems of its indigenous African communities. This was formalized in the Recognition of Customary Marriages Act of 1998, a landmark piece of post-apartheid legislation designed to give equal status to cultural practices that had long been marginalized. It was a massive step towards legal pluralism. And under many traditional customary laws in South Africa, polygyny is not only permitted, but is a long-standing and culturally significant practice. The Act, therefore, had to make room for it. It allows a man to have more than one wife under customary law. So, you have one law saying absolutely not and another saying yes, under certain conditions. It's a legal Schrodinger's cat. A man can be both monogamously and polygamously married at the same time, depending on which legal lens you're looking through. But of course, it's not a free-for-all. The Recognition of Customary Marriages Act put in some very important guardrails, primarily to protect the rights of the existing wife or wives. This is where it gets really interesting. If a man who is already in a customary marriage wants to take another wife, he can't just do it. He has to apply to a court for approval. This is a crucial step. The court's job is to approve a written contract that will regulate the future matrimonial property system of his marriages. Essentially, the man has to come up with a plan that explains how he's going to divide his assets and property between his current wife and his prospective new wife. The goal is to ensure that the first wife is not left financially disadvantaged by the arrival of a second. It's a legally mandated prenup for a polygamous situation. The court must be satisfied that the plan is equitable and just. The first wife has to be involved in this process. Her rights and interests must be protected. This gives her significant power and a legal voice in the matter, a stark contrast to systems where the husband can make the decision unilaterally. The court is there to act as a referee, ensuring that the introduction of a new spouse doesn't financially ruin the existing family structure. This judicial oversight is a modern and, frankly, progressive take on regulating a traditional practice. It acknowledges the cultural importance of polygyny for many South Africans while simultaneously trying to mitigate one of its most common pitfalls, the economic vulnerability of the first wives and their children. It's an attempt to weld together tradition and modern constitutional rights of equality. So in South Africa, you have this fascinating duality. A civil marriage is strictly monogamous. A customary marriage can be polygynous, but only with the court's permission and a solid financial plan in place. A man cannot be in a civil marriage and a customary marriage at the same time. He has to choose his path. It's a complex, hybrid system that reflects the country's diverse cultural and legal heritage. It's not perfect, and it's full of challenges, but it's a unique attempt to balance individual rights, cultural traditions, and legal equality. Now, let's journey to the world's largest archipelago, Indonesia, a nation of over 17,000 islands. It's a place where diversity isn't just a buzzword, it's a daily reality. And as you might expect from a country with hundreds of ethnic groups and languages, its approach to polygamy is anything but monolithic. On the surface, Indonesia's national law views marriage as a monogamous institution. However, like a dense jungle, if you look closer, you'll find a whole ecosystem of legal pathways and exceptions that allow for polygamy. The primary law governing marriage in Indonesia is the Marriage Law of 1974. This law sets the default as monogamy. However, it contains a crucial unless clause. It states that a court can grant a husband permission to have more than one wife, but only under very specific and stringent conditions. This isn't a simple rubber stamp process, it's designed to be a significant hurdle. It's the law's way of saying, we'd really rather you didn't, but if you absolutely must, here's a mountain of paperwork. So, what are these conditions? First, the husband must obtain the consent of his existing wife or wives. This consent must be given voluntarily, without coercion. This is a powerful provision, giving the first wife a legal veto. Secondly, the husband has to prove to a religious court that he can financially support all of his wives and their children, and, crucially, that he can guarantee he will treat them justly. Again, we see this theme of justice and financial stability as a prerequisite. But there's a third layer. The husband must also have a valid reason for wanting a second wife. The law lists specific acceptable reasons. For instance, if the first wife is unable to bear children, if she has an incurable disease or disability that prevents her from fulfilling her wifely duties, or if she is unable to perform her duties as a wife for other reasons. This medicalizes and codifies the justification, moving it beyond a simple desire for more partners. The process is rigorous. The husband files a petition with the religious court. The court then summons the first wife to confirm her consent and to hear her side of the story. It assesses the husband's financial documents and evaluates his character. It's an intrusive and often lengthy process. Because of these difficulties, many men who wish to practice polygamy bypass the legal system altogether through unregistered Sirai marriages, which are recognized by religion but offer no legal protection to the wife or children. Now, here's where Indonesia's famous diversity comes into play. The rules can vary depending on where you are. The country isn't a single, homogeneous legal entity. For example, in the province of Aceh, which operates under a special autonomy agreement and implements a stricter form of Sharia law, the regulations and social acceptance of polygamy are different from those in, say, Jakarta. the local interpretation of Islamic law can have a huge impact. And it's not just about Islam. While Indonesia is the world's most populous Muslim-majority nation, it officially recognizes several other religions. On the island of Bali, which is predominantly Hindu, the story is different again. Balinese Hinduism, unlike most other forms of Hinduism, has traditionally allowed for polygamy. While it has become much rarer in modern times due to social and economic changes, it is not legally prohibited under their customary law or adat. This creates a patchwork of regulations across the archipelago. The national law provides a framework, but its application is filtered through local religious courts, provincial regulations, and deeply ingrained customary practices. In Bali, a man might enter a polygamous union under Hindu custom, while in West Java, another man might navigate the complex bureaucracy of the Islamic religious court to do the same. So, while Indonesia's official stance leans towards monogamy, the reality on the ground is far more complex. It's a system of stipulated legality, where polygamy is permitted but deliberately made difficult. The law creates a high barrier to entry, requiring consent, financial proof, a just cause, and judicial approval. It reflects a society grappling with the tension between modern legal norms, religious doctrine, and diverse cultural traditions, all playing out across thousands of islands. Let's move on to a country that presents a true paradox: India. India is the world's largest democracy, a nation with a secular constitution that strives to treat all citizens equally regardless of their faith. Yet, when it comes to family law, marriage, divorce, inheritance, it doesn't have one single law for everyone. Instead, it has a system of personal status laws, where the rules you live by depend on the religion you belong to. It's a legal framework that is both fascinatingly pluralistic and maddeningly inconsistent. For the vast majority of Indians, Hindus, Sikhs, Jains, and Buddhists, polygamy is strictly illegal. The Hindu Marriage Act of 1955, which applies to these groups, explicitly enforces monogamy. If a person covered by this act marries a second time while their first spouse is alive and they are not divorced, the second marriage is void, and they are liable for prosecution for the crime of bigamy under the Indian Penal Code. The law is clear, unambiguous, and absolute on this point. However, and this is the crux of the whole issue, that law does not apply to India's Muslim population, which numbers over 200 million people. India's Muslims are governed by the Muslim Personal Law, Shariat Application Act of 1937. This colonial-era law essentially states that in matters of personal status, the rules of Islamic law, or Sharia, will apply. It was a British attempt to manage its diverse subjects by letting them keep their own family laws. And as we've already discussed in the context of Saudi Arabia, traditional interpretations of Sharia permit polygyny. This means that in India, a Muslim man is legally allowed to have up to 4 wives. This creates a bizarre legal anomaly. A man's right to have multiple spouses is determined entirely by his religious identity. 2 men, neighbors in the same apartment building in Mumbai, could have completely different marital rights based on whether they are named Ramesh or Rashid. This legal exception is one of the most hotly debated topics in Indian politics and society. Proponents argue that it is a fundamental aspect of religious freedom, a right guaranteed by the Indian Constitution, and that the state should not interfere in the personal laws of a minority community. They see it as a cornerstone of India's secular promise to protect its diverse cultures and religions. On the other hand, critics, including many women's rights activists and secularists, argue that this system is discriminatory. They contend that it violates the constitutional principle of equality, particularly gender equality, by subjugating Muslim women to a practice that is denied to women of other faiths. They point out that allowing polygamy for one group while criminalizing it for others makes a mockery of the idea of a secular state with equal laws for all citizens. This debate has been raging for decades and is central to the call for a uniform civil code, a proposed law that would replace the various personal laws with one single set of rules for every citizen, regardless of religion. The idea of a uniform civil code is even mentioned in the Indian Constitution as a directive principle, a goal for the state to aspire to. However, attempts to implement it have been met with fierce political resistance. The situation is further complicated by the fact that there are no specific legal statutes in India that lay out the conditions for a Muslim polygamous marriage, like the equality or financial proof requirements we've seen elsewhere. The practice is governed by uncodified traditional interpretations of Sharia, which can vary. This lack of a formal legal framework can leave wives with little recourse if the conditions of justice and equality are not met. So, India presents a unique case. It's not a country where polygamy is legal across the board, nor is it completely illegal. It's legal for a specific demographic slice, Muslim men. This exception, born from a colonial-era policy and preserved in the name of religious freedom, has created a deeply polarized and legally complex situation. It's a stark illustration of the challenges a secular democracy faces when trying to reconcile the principle of equality before the law with the right to religious and cultural autonomy. Our final destination is the most populous country in Africa, Nigeria. A vibrant, complex, and deeply religious nation, Nigeria's legal system is, much like South Africa's, a tale of two distinct frameworks operating in the same country. But here the dividing line isn't between civil and customary law, it's a geographical and religious divide between the northern and southern parts of the country. This creates a stark legal map where your marital rights can change dramatically just by crossing a state line. At the federal level, Nigeria has a civil law that governs marriages. The Marriage Act, which applies to all citizens who choose to marry under it, is strictly monogamous. Just like in India or South Africa's civil system, a civil marriage in Nigeria is defined as a union between one man and one woman. Attempting to enter into a second civil marriage while the first is subsisting is the crime of bigamy, and it is punishable by law. This is the legal standard in the southern, predominantly Christian part of Nigeria. However, Nigeria is a federal republic made up of 36 states, and since 1999, 12 of the northern states have chosen to adopt Islamic Sharia law to govern civil and criminal matters for their Muslim populations. These states, including Kano, Zamfara, and Sokoto, operate a parallel legal system based on Islamic jurisprudence. It's a system that exists alongside the federal civil law, but for Muslims within those states, it takes precedence in personal matters. And within these 12 northern Sharia states, polygyny is legal. Following the same principles of Islamic law we've seen elsewhere, a Muslim man residing in one of these states is legally permitted to marry up to 4 wives. The marriage is conducted under Islamic law, is recognized by the state, and grants full legal rights to all wives and children. This isn't just a customary practice, it's codified state law. This creates a profound legal and cultural split within the country. In Lagos or Port Harcourt in the south, a man with 2 wives would be seen as a bigamist committing a crime. In Kano or Katsina in the north, that same man, provided he is Muslim and followed the correct Islamic procedures, would be seen as a legally and respectably married individual exercising his religious rights. The very definition of a legal marriage is geographically dependent. As with other Islamic legal systems, there are conditions. The husband is expected to have the financial capacity to care for all his wives and children without favor. The principle of ADL, or justice and equality, is paramount. He must provide equally for them in terms of housing, food, clothing, and the time he allocates to each. Failure to do so is considered a sin and can be grounds for a wife to seek divorce in a Sharia court. However, unlike the court-mandated contract we saw in South Africa, the enforcement of this equality in northern Nigeria often relies more heavily on social pressure and the religious conscience of the husband, while a wife can bring a complaint to a Sharia court. The proactive premarital judicial review of a man's finances is not typically part of the process. This places a greater burden on the wives to seek legal recourse after the fact if they feel they are being treated unjustly. The practice is deeply embedded in the culture of northern Nigeria, particularly in rural areas and among the traditional elite. For many, it is not just a legal right, but a cultural norm and a sign of status and wealth. It is seen as a way to build larger families, create alliances, and provide for women who might otherwise remain unmarried. This social acceptance means the practice is far more open and common in the north than in places where it is merely a legal exception. So, Nigeria offers a powerful example of legal pluralism within a federal system. The country is effectively partitioned into two zones when it comes to marriage law. The South operates under a monogamous civil law system inherited from its British colonial past. The North, for its Muslim citizens, operates under a polygynous Sharia law system. It's a stark reminder that in a country as large and diverse as Nigeria, there is often no single answer to the question, what is the law? The only correct answer is, it depends on where you are. So there you have it, a journey through 5 countries and 5 very different legal landscapes for polygamy. As we've seen, there is no one-size-fits-all answer to where and how polygamy is legal. The laws are a complex tapestry woven from threads of religion, colonial history, constitutional rights, and local customs. In Saudi Arabia and the Sharia states of Nigeria, it's a practice deeply rooted in and regulated by Islamic law. In South Africa, it's a constitutional balancing act between civil law and customary traditions, with the courts acting as a referee. In Indonesia, the state makes it legally possible but bureaucratically difficult, creating a high barrier to entry. And in India, it exists as a controversial legal exception for one religious community in a nation that is otherwise secular. What is clear is that the legality of polygamy is rarely a simple yes or no. It's almost always a yes, but only for this religion. Yes, but only with court permission. Yes, but only if you can prove you'll be fair. These stipulations reveal what each society values and fears, whether it's protecting religious freedom, ensuring gender equality, or preventing the financial destitution of women and children. This has been just a brief overview, and the laws are constantly evolving, subject to court rulings and legislative changes. If you're interested in this topic, or if it has personal relevance to you, I strongly encourage you to do your own deep dive. Check the specific up-to-date laws and customary practices in the region you're curious about. Talk to legal experts on the ground. The reality is always more nuanced than a 10-minute video can capture. The world is a complicated place, and so are the ways we choose to form families within it. Thanks for watching.